Chapter 17, Negotiable Instruments, a partial chapter, presented by Kelly Herzik. In Chapter 17, we are only going to be covering part of the chapter up through Lesson 17-4, which ends on page 356. Most of the rest of the chapter covers checks. Checks are still in use, but they are being used less in the current economy, so I've elected to cut this portion of the chapter out, particularly given the level of information this class covers each week. We will discuss some basic check issues as we discuss negotiation in this chapter and as we discuss holder in due course in the next chapter, Chapter 18. In this lesson, we will be discussing negotiable instruments, types of negotiable instruments, the law of negotiable instruments, negotiation, and some relevant banking issues. We will begin with negotiable instruments. Once there's a sales contract in place, the buyer needs to pay for the goods agreed upon. Payment usually comes in one of three general ways: in cash, with credit arrangements, and we'll discuss those when we examine secured transactions, or through a cash substitute such as a negotiable instrument. A negotiable instrument is primarily a cash substitute. It is a written document containing the signature of the creator who makes an unconditional promise or order to pay a sum certain of money either at a certain time or on demand by the holder of the instrument. It is an acceptable means of transferring or exchanging value from one person to another. Negotiable instruments may be checks, certificate of deposits or CDs, drafts or promissory notes used in exchange for goods, services, or business financing. Negotiable instruments are used usually to avoid using cash, particularly large amounts of cash, or currency or precious metals like gold. Generally, they are known as commercial paper. They are governed by Article 3 of the UCC, which labels them negotiable instruments. Now, before the midterm, we spent a large amount of time talking about contracts, but you should know that contracts can also be and are commercial paper. Contracts are commercial paper, both of those formed under the common law and the UCC. Contracts may be assigned and circulated in the commercial world. Remember that contracts have the implied warranty of assignability under common law. Exceptions to assignability are contracts that have non-assignment clauses, which we've discussed before, and personal contracts. However, using contracts as a substitute for payment can be problematic, especially if there's a problem with the original consideration. Let's take a look at this example. Suppose Bob sells Betty a used car and Betty agrees to pay Bob $5,000 on demand. Rather than take the money, Bob assigns his rights under the contract to be paid the $5,000 to Larry in exchange for another car. Larry will then get the money for the car he sold Bob from Betty under the assigned contract and everyone is satisfied. However, if the original car Betty bought turns out to be a lemon, she may refuse to pay Larry and claim Bob breached the contract. Then Larry will have to sue Bob, which is inefficient. As long as Betty is on solid legal footing, Larry has no recourse against Betty because he steps into Bob's shoes in the original contract. If Bob breaches the original contract, Larry cannot get his money from Betty and must sue Bob. Next, we'll discuss the types of negotiable instruments. Article 3 of the UCC recognizes these types of negotiable instruments. Notes. A note is a promise to pay by the maker, which is the person signing the note, to a payee. Notes are two-party instruments. Then there are drafts. A draft is an order by a drawer, which is the person signing the draft, to a drawee, like a bank, to pay a payee. Drafts are by their nature three-party instruments. Then there are certificates of deposit. A CD is a promise by a bank to a payee to pay a certain amount of money at a future time. It is a note of the bank and usually pays a set level of interest, which right now is pretty small. The last category are checks. Checks are a specific type of draft. drawn by the owner of a checking account, ordering the bank to pay the payee from the drawer's account. Cashier's checks, traveler's checks, and certified checks are examples of check types. Now, notes and drafts can either be demand instruments or time instruments. With demand instruments, the payee or subsequent holder can demand payment at any time. With time instruments, payment can be made only at a specific time in the future. CDs are generally a time instrument, while checks are always demand instruments, even if they're post-dated. That doesn't matter, they're still considered a demand instrument. Next, we will discuss the law of negotiable instruments. For an instrument to be negotiable, it must meet the specific requirements of negotiability. A negotiable instrument is a term of art. Instruments can be negotiable or not negotiable, but negotiability is a specific term and has specific protections under the law. If an instrument is not negotiable, it is still a valid and enforceable instrument. It just does not have those protections that negotiability provides. To be negotiable, an instrument must be a written document, signed by the creator of the document, have an unconditional promise or order to pay, have a sum certain in money to be paid, have a payment term that is either on demand or at a fixed future time, which is a time certain, which I just mentioned before on the previous slide, and contain either the words of negotiability like to the order of, or words indicating that it is a bearer instrument. Now, these 6 requirements for negotiability come directly from the definition of a negotiable instrument in the UCC. A negotiable instrument is a written document that is signed by the maker or drawer with an unconditional promise or order to pay a sum certain in money on demand or at a time certain to the order or bearer. UCC Section 3-104A is where that definition comes from. Remember, negotiability is not the same as enforceability. An instrument can be enforceable but not negotiable. Let's break down the elements of negotiability and discuss them in a little bit more detail. The first element, of course, is a written document. There must be a written document. No oral negotiable instruments are permitted. Written documents must have both relative permanence or longevity and movability or mobility of transfer. Next is the signature of the maker or drawer. It must have that signature. Now, UCC and cases interpreting it are fairly liberal on what constitutes a signature. Now, we've already covered what constitutes a signature under the UCC in previous lessons, but as a refresher, it can be a full signature, initials, or a mark such as an X. The party's signature or mark must be intended to be a signature on the document. It can be anywhere on the document. It does not have to be at the end. It can be made manually, electronically, or by machine or device, such as a signature stamp. It can be signed with any name or even an assumed name, including a trade name. I do want to point out that a handwritten negotiable instrument satisfies the writing requirement and the signature requirement even without a formal signature, since the handwriting on the instrument shows the intent of the maker. So those two things are kind of compressed when you're looking at a handwritten negotiable instrument. They're very rare. They usually happen in families, but you sometimes do see them. Now, sometimes you don't see the signature of the maker or drawer directly. Rather, you see the signature of the maker or drawer on a negotiable instrument through the signature of an agent. Now, we've already discussed agency law in Chapter 20, but I think it's very important to discuss agency signatures because, particularly on negotiable instruments, agents can run into serious trouble depending on how they sign a negotiable instrument. A signature of an agent who acts for a principal or appears to act for that principal through apparent authority on an instrument binds the principal as if it were the principal's signatures. That's straight up agency law. The agent is not liable if he signs his own name and makes clear he's doing so as an agent. For example, Joe Doe as agent for ABC Painting Inc. It's very clear from that signature block that Joe is not signing in his personal capacity, but only in his capacity as an agent for ABC Painting. But problems arise when the agent, although authorized, signs in an incorrect way, and you see this all too often. There are usually three possibilities. The agent signs only his own name. The agent signs both names but without any indication of any agency. For example, the signature is ambiguous. Are both parties to be liable, or is only the agent to be liable? Or the agent signs as an agent but doesn't identify the principal. All these are problematic on a negotiable instrument. Now, the UCC provides that in each case, the agent is liable to a holder in due course who took the instrument without notice that the agent wasn't intended to be liable on the instrument. So holders in due course have higher protections from these signature problems. Now, as to any other person, the holder, just a plain holder or transferee, the agent is liable unless she can prove that the original parties to the instrument did not intend her to be liable on it. So she has an extra defense there against holders that she doesn't have against holders in due course. Now, there is a special exception for checks. Section 3-402C of the UCC says that as to a check, if an agent signs his name without indicating agency status, but the check has the principal's identification on it, that would be in that upper left-hand corner, the authorized agent is not liable because it has the agent's signature, but it's clear that it's the principal's bank account, it has the principal's account number, it has the principal's bank, and it has the principal's information at the top. Now, it's very important to note the different defenses an agent has to a defective signature that does not properly show his agency if he's sued on that instrument. If there is a signature defect of an agent on a negotiable instrument, such as a note, for a subsequent holder in due course, remember there's less defenses, the agent is going to be liable on the note as long as the holder in due course takes without notice that the agent was not intended to be bound. That's it. If there's no way for the holder in due course to tell that the agent wasn't meant to be bound, no matter what the original intent of the parties, the agent's on the hook for the contract. Now, if the subsequent holder is not a holder in due course, the agent is still liable but has the opportunity to prove as a defense that the original parties to the note did not intend for the agent to be liable. Now, that defense is not available against a holder in due course. Next, we're going to discuss unauthorized signatures of a maker or drawer on an instrument. False manual signatures, forgeries, or automated signatures, such as one done by a stamp, machine, or e-signature, can be applied by third parties without authority of the maker or drawer. Generally, under the UCC, Section 3-403, an unauthorized signature is not binding on the maker or drawer. It only binds the fraudster or the unauthorized signer. However, there are exceptions, as there almost always are. Even if an automated signature is affixed without authority, the signature may be valid if the maker or drawer intended his name to be affixed to the instrument. The unauthorized signature can be ratified by the maker drawer after the fact. Remember, principals can ratify the unauthorized acts of agents after the fact. It's the same concept of ratification. If negligence contributed to an instrument's alteration or forgery, the negligent person cannot assert lack of authority against a holder in due course or a person who in good faith pays or takes the instrument for value or for collection. For example, suppose Larry leaves his signature stamp laying around on his desk rather than locking it up. If Betty sees the stamp, steals it, and uses it to create a false instrument to Bob to pay for a car for Betty, Larry's signature on the instrument is clearly unauthorized. In addition to Betty, who created the fraudulent instrument, however, both Larry and Bob could be liable based on comparative negligence concepts. Larry could be liable on the instrument because he was negligent leaving his signature stamp lying out. And Bob could be liable to a holder in due course if he transfers the instrument if the circumstances made taking the instrument suspicious. Employers can also be liable if an employee or independent contractor with responsibility to sign documents does so fraudulently. The next required element of negotiability is an unconditional promise or order to pay a sum certain. The promise or order to pay must be specific and not implied. The language must be affirmative. It must be expressly stated. For example, a common IOU that merely acknowledges a debt cannot be a negotiable instrument because it does not create the language of payment. It does not contain a promise or order to pay, the pay to the order of language. The promise or order to pay must be unconditional, meaning it cannot be contingent on something else happening. For example, language would be problematic if it says, I promise to pay if. I promise to pay if is a conditional promise to pay. It has to be unconditional. I promise to pay X. Negotiable instruments must be payable in national currency, dollars, euros, etc. It cannot be payable in gold or other precious metal, gems, or goods, which are not currencies. Even if payable in either both dollars and gold, that would not satisfy the requirement for a sum certain. It must be national currency only. Now, if it's a mixed contract of money and gold or money and gems, these could still be enforceable contracts, but the contract would not be a negotiable instrument. The next required element for negotiability is payable at a time certain or on demand. A negotiable instrument must be payable either on demand or at a time certain that can be determined from the instrument itself. Most often, a negotiable instrument has a specific date. If the instrument is silent on the time of payment, the UCC presumes it is a demand instrument. Demand instruments like a check are payable as soon as they are issued. If an instrument is dated and then says it's payable 10 days after the date on the face of the instrument, then it is a negotiable instrument because a specific date can be calculated from the document itself. However, if there is any vague or indefinite language such as payable at a future date that is not a time certain, then the instrument is not negotiable. Language that says payable 10 days after the delivery of the goods when no delivery date is in the instrument would also render the instrument non-negotiable because you can't figure it out. It could also be non-negotiable if this language is construed to be a condition of payment. Like, I won't pay you until the goods are delivered. That would be a conditional promise to pay. The last required element for negotiability of an instrument is that the instrument must have words of negotiability. For an instrument to be negotiable, it must indicate that it was created to be transferred. The phrase pay to the order of is a common phrase of negotiability. It's the magic words. When it is payable to the order of a specific payee, a specific person, this is called an order instrument. Pay to the order of Bill Jones. That would make it an order instrument. When an instrument is not payable to a specific person, this is a bearer instrument. For example, a check for $500 that is dated and signed, but the payable to order line is blank or payable to cash would create a bearer instrument. Bearer instruments are treated like cash. Anyone, even a thief that has possession of a bearer instrument, can present it for payment and cash it. Endorsing an order instrument, signing it on the back, converts the instrument into a bearer instrument capable of being cashed by anyone in possession of it. So you have to be very careful what you do with instruments as you endorse them on the back or you sign them. Now, think about the words of negotiability. I mentioned one, pay to the order of Bill Jones. For example, payable to bearer is words of negotiability. Payable to cash, pay to the order of Larry Smith. These are all acceptable words of negotiability, and that creates the ability to transfer the instrument down the line. Once the 6 elements of negotiability are satisfied, the instrument is deemed negotiable and it's able to be transferred. Now we will discuss negotiation and delivery. Once a negotiable instrument is created and meets the 6 elements, it can be transferred to another party through a process called negotiation. Negotiation is the transfer of rights to a negotiable instrument from one party to another. A holder is a person who has possession of a bearer instrument or who has possession of an order instrument payable to them specifically. You're a holder if you have bearer paper in your hand or if you have an instrument payable to you. A bearer instrument only requires delivery to the holder for negotiation. In other words, because it's like cash, you can just hand it along just like it's a 20. You can pass a bearer instrument physically from one person to the next as long as you intend to deliver it. Now, an accidental transfer of bearer paper is not delivery. If the instrument blows off the desk and someone finds it, this is not negotiation because there was no intentional transfer of the instrument. An order instrument requires both delivery to the holder and endorsement by the original payee of the instrument for negotiation. So you have to transfer bearer paper by hand to hand only. But when you get to order paper, when it's payable to a person, that person has to both sign the back of the document as the endorser and then hand it off. It requires both a signature and a physical delivery. And delivery is the intentional physical transfer of the instrument from one party to another. Next, we're going to discuss endorsements. Now, order instruments must be both endorsed, signed, and delivered to be negotiated. We just discussed that on the previous slide. The endorsement is the signature of the original or the current payee on the order paper. The person creating the endorsement is the endorser, and the person receiving the endorsement is the endorsee. Normally, an endorsement is placed on the instrument like the back of a check, but if there's no room on the instrument, an allonge may be attached to the instrument. An allonge is just a blank piece of paper that is firmly attached to a document for endorsements. It gives you extra room to write. Staples will work, but a paper clip won't. And the reason for that is that an order instrument can have several endorsements. Suppose Larry writes a check to Bob to pay for services rendered. Bob can either take the check to the bank, endorse it, sign it on the back, and then cash it, or he could endorse it specifically to Betty to pay for an item he's buying. It would say, pay to the order of Betty Jones, signed Bob Smith. And that would specifically endorse it to Betty, and then Betty would have possession of the instrument. And that could go on several times until there's no place to write. And so then you have to attach an allonge to the original instrument firmly with a staple so that you can continue to endorse that piece of paper and it can go on down the line. Now there are 3 types of endorsements: unqualified, qualified, and restrictive. And we'll talk about those next. Next, we'll discuss endorsement types. The first endorsement type is an unqualified endorsement, and they come in 2 types themselves, blank and special. A blank endorsement is simply the signature of the payee or last endorsee and nothing else, which turns the instrument into bearer paper. For example, suppose Bob has a $50 check payable to Bob Smith. If Bob Smith flips that check over and signs his name Bob Smith on the back with nothing else, he's converted that order paper to bearer paper. And if Bob doesn't cash it or deposit it, but rather loses it, and someone else picks it up, they can cash it because it's bearer paper. It's just like cash. And Bob will be out the $50 because he used a blank endorsement to convert order paper to bearer paper. Now, a special endorsement is payable to a specific endorsee and signed by the endorser, such as pay to the order of Betty Smith, signed Larry Jones. Now, you'll see in a lot of my examples that I say pay to the order of. To the order of is not actually required for negotiation. To the order of are not words of negotiation that are required in an endorsement, okay? But it makes it clearer and keeps the instrument as order paper. If it says pay to the order of someone, it's very clear that you're intending to keep the paper as order paper. Pay to Betty Smith will do the job, but I don't like having any kind of ambiguity or any wiggle room for someone, particularly in negotiable instruments. Now, a qualified endorsement is an endorsement that passes a negotiable instrument with restrictions. For example, writing without recourse on the back of a check. Now, without recourse means that you are disclaiming liability or responsibility for future non-payment of the instrument. The person who accepts a check or other instrument endorsed without recourse is assuming the risk of default and can't look up the ownership chain to the endorser who qualified his endorsement in this manner. A qualified endorsement makes it more difficult for a thief or embezzler to cash a check. It can also limit the liability of the endorser if the paper is dishonored. Finally, there are restrictive endorsements. These endorsements place limitations on the use of a negotiable instrument. For example, writing "for deposit only" on the back of a check. For deposit only means the paper cannot be cashed at the counter and can only be deposited in an account owned by the endorser. A restrictive endorsement can restrict to whom the paper may be transferred and/or how the transferee can use the paper. Next, we'll talk about endorsement problems, specifically forged signatures on instruments. In criminal cases such as fraud and embezzlement, signature problems are common. Under the UCC, Section 3-403A, a forged signature has no legal effect as the signature of the drawer, the signature of the customer, meaning that if a bank pays a check with a forged signature of their drawer, their customer, the bank is liable for the amount of the check. There are, of course, exceptions. If the drawer, the customer, was negligent and that negligence substantially contributes to the forged signature, the bank is generally not going to be liable. For example, leaving a signature stamp lying around. That always creates a problem. Bank customers have a duty to review their statements for altered or forged checks, and if they fail to do so or fail to give reasonable notice to the bank promptly after a statement is available of a forged check, the bank will generally not be liable. Now, this is governed by UCC Section 4-406. So you have to ask yourself, what is reasonably prompt notice? Under Section 4-406F, for one forged item, you generally have 1 year to notify the bank, but there's a big but there. Most banks have time limits in their depository agreements, and there may be state law interpretations of what reasonably prompt notice means. I always tell people to use 30 days as their window, especially since someone may try to write more than one check on your account, and the rules for multiple items are stricter. If there are multiple forgeries, the account owner needs to notify the bank of the first one within 30 days or could risk being liable for the entire string of bad checks. Now, comparative negligence does apply between the bank and the account holder in a negligent situation. If the account holder says the bank is negligent, they have the burden. If the bank says the customer is negligent, they have the burden. But regardless of either party's negligence, a customer has that 1 year after the statement is made available to discover and report an unauthorized signature on any alteration on the item to the bank. And failure to do so precludes the customer from asserting against the bank the unauthorized signature or alteration. Basically, you have a 1 year statute of limitations for forged checks. But what happens when you receive a fraudulent check from another party and deposit it? Well, I have bad news. Generally, if you take a fraudulent check and deposit it, and the check is later discovered to be fraudulent, your bank can reverse the deposit and debit your account for the full amount of the check. You will then have to chase the person who gave you the fake check, if you can. Next, we'll talk about forged endorsements and alterations to the instrument itself. Forged endorsements. A drawer is not liable for fraudulent endorsements. If you write a check to someone and they lose it and someone does a forged endorsement on the back of that check to cash it, you as the original maker of the check, the original drawer, are not liable on the forged endorsement. Generally, the first party to accept an instrument with a forged endorsement is ultimately going to be liable for the loss because a forged endorsement does not transfer title to the instrument. If you take it, generally you get stuck with the loss. A drawer does have a duty to review his or her bank statements for fraudulent endorsements and then notify the bank. The drawer, the customer, must report all forged endorsements within 3 years of receiving the item back or the statement showing the forged item. If you don't, then the bank will no longer be liable for the loss. Then there are alterations. These are unauthorized changes to an instrument that modifies the obligations of the parties to the instrument. If a bank pays an altered check, it is liable for the loss generally. However, if the maker of a check was negligent, such as leaving big spaces that would allow alteration, or a blank amount, then the maker can be liable for the loss instead. If you write a check to someone and you make it possible for them to change 100 to 1,000 because you left a blank or you left a lot of blank spaces so that they could easily do it, you could be liable and the bank could try to push the liability for the negligence back on you. Now, the customer has a duty to review his statements and give prompt notice to the bank, and comparative negligence will also apply to apportion blame between the parties. The bank blames you for negligence, basically leaving blank spaces. You may also say that the bank was negligent in paying the item, and so the comparative negligence will apply between the two parties. Now let's discuss some non-criminal endorsement problems. Besides criminal signature problems, there are several non-criminal endorsement issues that can arise. The biggest one is misspelled names. If an instrument has a misspelled name, the holder may endorse the instrument with the misspelled name, the holder's actual name, or both. The best practice is to sign it with the misspelled name and then sign it right underneath with the actual name so that everything is clean and clear. But what about when the instrument is payable to a legal entity? Who signs? If an endorsement is made payable to a legal entity that is an estate, an organization, a partnership, a corporation, the instrument may be signed and endorsed by the legal representative. And usually the signature card at the bank, the legal representative is required to sign it so that the bank knows who in the organization can sign on behalf of that organization. Now, if it's payable to a government entity or public office, the person holding the office may endorse the item, such as a county tax collector. If you pay your taxes to Sedgwick County tax collector, whoever is holding the office at that moment can sign it. Then there is a problem with alternative or joint payees. You sometimes see this. If an instrument is payable to more than one person, there are two possibilities. They can be joint payees, and that means that both parties must endorse it. And this usually is created by language that says payable to Jones and Smith. It's that and that creates the joint payees, and then both have to sign the instrument for it to be endorsed and negotiated. Or it could be alternative payees, and that means that either party can endorse it, like payable to Jones or Smith. The or creates the alternative, and that means either party can endorse it and pass it on. It doesn't have to be both signatures. If it's not clear, courts usually find that the payees are alternative, such as payable to Jones, Smith. That will be interpreted as an alternative payee. Now, while checks are still being used, electronic banking is on the rise. So I want to point out a few things with respect to electronic banking, specifically electronic fund transfers. Consumer electronic fund transfers are governed by the Electronic Fund Transfer Act of 1978. The Federal Reserve Board issues regulations that governs ETFs under Regulation E. ETFs are such things as debit card payments, ATM transactions, and paycheck direct deposits. Under the Electronic Funds Transfer Act, banks must notify customers of their rights regarding EFTs. If a debit card is lost or stolen, a customer must notify the bank within 2 days. If prompt notice is given, the customer is only liable for the first $50 of loss. But if notice is not promptly given, the customer's liability for losses rises to $500. Now, bank statements must show ETFs, and customers have 60 days from the statement to notify the banks of any errors in ETFs. Now, commercial fund transfers are generally covered by the UCC in Article 4. Wire transfers are common between commercial parties and are usually handled either by the Federal Reserve Network, which is Fedwire, or the New York Clearinghouse Interbank Payment Systems, which is called CHIPS. And over $1 trillion are handled through these systems every day. The last issue I want to talk about briefly is online banking. Technology in banking is changing rapidly, and gone are the days when everything is done by check or at the bank window in a physical location. More and more people are using online banking products than ever before. E-payments are becoming more prevalent, shifting away from physical currency and physical checks. An electronic payment, an e-payment, is any kind of non-cash payment that doesn't involve a paper check. Methods of electronic payments include credit cards, debit cards, and the ACH Automated Clearinghouse Network. The ACH system comprises direct deposit, direct debit, and electronic checks or e-checks. If you pay your credit card directly at the company's website, you are usually using the ACH system and creating an e-check to pay them. The Electronic Funds Transfer Act and the UCC generally apply to these types of transactions. Then there is digital cash. Digital cash is e-money stored electronically on microchips, magnetic strips, or other computer media. These are stored value cards like gift cards, and they contain e-money stored on electronic strips. Unfortunately, Regulation E under the EFTA does not apply to e-money, and therefore there's limited recourses on gift cards if something goes wrong. Online banking via the internet and smart apps is also much more popular and allows people to access their accounts and balances, transfer money, pay bills, and apply for loans, to name a few services. Now, banks are generally liable for security online, and if account is hacked, the EFTA rules apply. We discussed those on the previous page. Now, banks can also collect information from you as you use their online services, but customer privacy in online banking is generally governed by both the Right to Financial Privacy Act of 1978 and the Gramm-Leach-Bliley Act. You have protections from the bank sharing or disseminating your private information to third parties. This is the end of Chapter 17.